Good afternoon. I'm Lana Ulrich and House Counsel here at the National Constitution Center. And it's my great pleasure to welcome you to today's program on this historic day after the Eagles have won their first Super Bowl championship. Yeah. Before we begin, I'd like to just share some information about some of our upcoming programs and events before we get into today's program. This week, the National Constitution Center will present a retrospective on the constitutional legacy of Justice Antonin Scalia on the anniversary of 2 years after his passing, and this is available for CLE credit for all of you attorneys out there. And later this month, we'll present a newly added event in partnership with C-SPAN. The program will discuss the second season of C-SPAN's upcoming Landmark Cases series, and it's going to feature our president and CEO, Jeffrey Rosen, as well as constitutional scholar Akhil Amar and others. So definitely check that out. And this month, we'll also host a special members program on the role of dissent throughout American history, which is open to NCC members only. If you want to purchase tickets or for more information, please visit constitutioncenter.org/debate. And if you're not a member and you're interested in becoming one, you can visit the membership table directly outside for more information on how to join. You can receive free tickets to our daytime programs, discounted tickets to evening events, all while supporting our nonpartisan nonprofit mission. And so now it's my pleasure to introduce today's guests. Patrick Charles is the author of numerous historical and legal publications on the Second Amendment. His writings on the Second Amendment have been cited by the 2nd, 3rd, 4th, 5th, 7th, 9th, and the District of Columbia circuits. And his first book on the subject, The Second Amendment, The Intent and Its Interpretation by the States and the Supreme Court, was cited by Justice Breyer in the landmark case of McDonald v. City of Chicago. He's currently the senior historian for U.S. Special Operations Command, and he's here today to discuss his new book, Armed in America, A History of Gun Rights from Colonial Militias to Concealed Carry. Yes. And Brannon Denning is the Associate Dean for Academic Affairs and a professor at the Cumberland School of Law at Samford University, where he teaches constitutional law. And he's also the co-author of Guns and the Law, Cases, Problems, and Explanation with Andrew McClurg, and Bitker on Regulation of Interstate Foreign Commerce, among other numerous books on constitutional law. So please join me in welcoming Patrick Charles and Brannon Denning. All right, so Patrick, in the introduction to your new book, you discuss how when you were a law student, you first became interested in the subject of the Second Amendment as this case, Parker v. District of Columbia, was making its way through the court. So could you tell us a little bit more about that case and why it specifically struck you and interested you in writing about the subject?
Yeah, so when I was an undergrad, I got a history degree. And in law school, I think everyone's trying to find their niche. Something that they feel comfortable with. And I remember when District of Columbia, Parker versus District of Columbia came down from the appellate circuit, and they talked about the history of the right to arms, and not only the history of the arms, but it was central to the holding of the case, to the analysis, the legal analysis. And that drew me in, being a history major. But what confused me was it was all history I was very unfamiliar with. Stuff that to me, intuitively did not add up. However, of course, as any historian would, you start asking questions, oh, how did you come to this? I started doing research. And that's really how I became involved. And I came to locate another misconceptions and myths, things that the court misconstrued. And I began delving, I would say about a year and a half, just spending time in the archives, looking it up. And I came to the opposite conclusion, at least as a matter of 18th century constitutional understanding, that the right was very intimately tied to the militia and not necessarily separate and distinct and only applied to an individual for self-defense purposes, as the court and later Heller comes to that rationale.
Great. So what kinds of historical sources did you start looking at?
I think like all people, we went to ratification history, went to the ratification debates, the understanding of the American Revolution, why it was fought, the standing army militia argument, the federalized militia argument, But I took it the next step. I really didn't find anything that really spoke to me. And to me, there's a lot of talk about the Bill of Rights and the Constitution being written by lawyers and understood by the greatest legal minds. So therefore, I thought, well, where do all the greatest legal minds learn the law? They learn it in laws and statutes and legal treatises, commentaries, and so forth. So I basically went an exhaustive look on the microfilm reels, mind you. This was before the internet got all this stuff done. And went through it and started reading all these colonial laws in every colony to see whether there was some kind of link with these terms and these phrases, whether it was justifiable homicide, hunting, and militia laws and so forth, to see if these terms, right to keep and bear arms and shall not be infringed, well-regulated militia appeared. And I did, and I found them all, probably not coincidentally, in militia laws, which to me showed that there was definitely this link to the militia concept. So my first argument was really related to that, is to this legal language clearly spoke to the militia conception of the right and in no ways invoked self-defense per se. That, of course, is not to say that the Founding Fathers did not exercise self-defense, carry arms, have arms, or own arms, or whatever. I just mean to understand the right itself and its importance in a constitutional republic.
Great. So, Brannon, you also wrote a case book about guns and the law. And in your research, did you similarly look at doing historical analysis of the Second Amendment?
Well, we were talking about this a little earlier. I mean, I'm a lawyer, not a historian, and history is obviously relevant. And I think that what has happened is that courts and others have sort of created what might be termed a usable past. I mean, just in the same way that you get some of the early First Amendment opinions where Justice Brandeis raps as eloquently about the framers' commitment to the tradition of free expression and free speech. Historically, that's very dubious. They would have restricted speech a lot more. I think there is this appeal to this past, beginning in the 18th century, the idea of us taking up arms, the government not having monopoly on the instruments of violence. I think that speaks to a particular relationship between the individual and the state that is very much a break with most of the rest of the Western world. And then you get this evolution up through the 19th century. There we're no longer talking about the Minutemen, we're talking about protecting the rights of newly freed African Americans. I think then it takes on a very much an individualist cast. But I think that individualist cast, which we've retained, I mean, most people, if you poll, 75% of people since they've done polling on it, think that the Constitution protects its individual right. And I think as a matter of constitutional law, sometimes we feel like we need to build a bridge to the past. And sometimes I think as Patrick and Saul Cornell and others would say, that's not necessarily done with according to Hoyle history, as practiced by historians. But I think for lawyers, it works, which is not to say that I have a little bit different reading on the history than Patrick does, but to be fair, he's done a lot more beavering away in the archives than I have. So maybe have just created my own usable past.
Well, to just continue to focus just a little bit on the history, since it was so important in the eventual opinion in Heller. If you look at the language of the Second Amendment, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So Patrick, in your book, you talk a little bit about the debate around how, when Madison was drafting the Second Amendment, what were the founders debating about the actual language of how the amendment was going to be phrased, if there was a debate at the time?
Well, what we have left from the surviving ratification debates is it's all centralized on this concern of federalizing the militia, the idea that the states were going to lose sole control over their militia and give power to the federal government. The same federal government that had plenary power over the standing army. This was seen to be a violation of Republican liberty, the states' rights, perhaps you could say at the time, if there was really such a thing. There was no talk at the ratification debates about self-defense. There is talk about the religious clause, about fear of allowing people that were religiously scrupulous to bear arms, forcing them to take up arms in defense of the country. Even if you look at the print culture, the press at the time, that are discussing the Second Amendment. So to be clear, during the Constitution's ratification and debates, that was all done in secret. There was no talk in the press about what's going on. However, the Bill of Rights was left open to the public, so people were writing editorials critical of what was going on back and forth, and all that critical commentary is all related to the militia. So that's more or less why I come to the conclusion. It had nothing per se to do with our individual conception of the right today. That doesn't say that the right didn't exist. It doesn't exist today. It's in Heller. Or that the right has never existed in our history. It did. It grew in the 19th century. But based upon that and that conception alone, the central idea of how important a militia was to the founding's era's view of Republican liberty cannot be overstated. And if you read chapter 3 of my book, you'll see just how that legal language, what it was meant to refer to. And people often get confused. They see terms like self-defense, self-preservation, and they immediately refer to that like, oh, well, that means my right to self-defense. But that's not what they're referring to. It's a broader legal language and philosophical discussion that's taking place in terms of communal liberty, which they were concerned about preserving.
Can I just jump in and make
Sure.
Some people may not, maybe we ought to unpack this idea of the militia versus a standing army and why that was such a debate. And I think we agree. So militia, I think when we say it today, people think of the National Guard, and it wasn't that. The framers, I think, would have considered the National Guard at best a quote-unquote select militia. The militia was the armed body of the people. I mean, drawn from, ages, 18 to 16.
Sometimes as low as 16, 14.
16, 14.
Yeah.
So these were people, usually white males, who would be available for communal self-defense, law enforcement, et cetera, when there was no professional police force. And according to the framers' understanding of English history was that in this glorious English past, you had a militia, it would protect the community. It wasn't used to invade foreign countries like standing armies were. It wasn't subject to executive control like standing armies were. So militia, represented sort of avatar of Republican virtue, small r Republican virtue, and communal good, versus standing armies, which were despotic, which were always in the service of tyrants and would be used to oppress the people. And so the framers had this very much an allergy towards standing armies. And for that reason, the Constitution, limits appropriations for armies to 2 years. So you have to refund the military every 2 years, and that reflects the framers' anxieties about having these large bodies of forces that could be used for military adventurism and to aggrandize power to the executive.
Yeah, I agree with that.
So Brannon, what do you make then of the inclusion of the language about the militia in the Second Amendment? Well,
and again, I mean, so because the militia was the people, it seems like to me that so a well-regulated militia, regulated, by the way, would have meant well-trained, not necessarily like, regulations from the EPA or something, well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. To me, it speaks to both. It speaks to trying to ensure that the militia would remain a force in being, and then protecting the ability of the constituent parts of that militia to be armed. So preventing sort of evasion of, hey, we need this militia to protect liberty, and this double security, we're not going to let you disarm individuals so that you would effectively render the militia useless at some point in the future. And Patrick has a different view, I'm sure, but in any event, that's my law professor's understanding.
Great. Well, Patrick, feel free to respond to what Brannon said, but then also maybe take us up to what the court actually held in DCB Heller and how they interpreted the amendment.
Well, the court agrees with what Brannon just said, that this idea of an armed people, you cannot have a militia unless the people are armed. And therefore, if you take away the people's arms, you can't have a militia. So you can't have one without the other. And it's a fact of life to them. But to the founding fathers, a well-regulated militia wasn't just about being well-trained, it's about being well-disciplined, adhering to the rule of law, about standing up and fighting, being loyal to government. There were all these larger tenets to being a quote-unquote well-regulated militia that were in Republican thought from the late 17th century to the late 18th century that go well beyond just having a gun. So I point out in my book is that many commentators would say having arms is not the greatest part of a well-regulated militia. It's actually the smallest part. The greatest part is the training, the discipline, the moving of the feet, working in concert, uniformity of arms, firing consecutive shot at each other. And many talked about how without that, you had an armed mob. And that armed mob was more dangerous to liberty than would be than for you just to have a gun. And they foresaw that. Now, I'm not saying that, and Brandon and I talked about this off stage, is that there weren't Americans at that time that would have said, yeah, this is exactly how the amendment is interpreted. The problem is we just don't have anybody that says that. I think the closest we have is Tench Cox, who refers to it in an editorial at the time when the Bill of Rights being ratified, saying, that they'll have their private arms. But I think Tench Cox also doesn't say anything in regards to, well, what happens when we lose the militia system and the standing army takes over our national security? I don't think Tench Cox answers that question. So we don't know. And you have to think about the importance of a well-regulated militia in the sense that if you are the militia, the idea is that you would never turn your arms on your own people, because if the arms are made up, if the military construct is made up of the people themselves, you would never hurt our own interests and you would never hurt your own people, because you live with those people and you couldn't take those people, especially from state to state, to fight whatever war you wanted to wage, go into foreign countries. I mean, they definitely didn't want to get involved in foreign conflicts. It's a very different time living then than it is today in our understanding of how we exalt the military today and how we actually probably look down on the militia more so than we would in years past.
Brannon, do you mean?
Yeah, well, and I think, I think there probably, if we were to spend, 2 or 3 hours, I think Patrick and I come to end up agreeing on more points that we disagree on. But I think, and he's right, the idea was that the militia was to be trusted with military force because they wouldn't ever abuse it and turn it on their own people, like a standing army might if it's made up of people from different states who don't know you and live next to you and such. As far as the Supreme Court, so fast forward 200 years, and finally, there was one case in the 20th century called United States versus Miller, where the court interpreted the Second Amendment or addressed the Second Amendment directly, and there had been no other case since then. And so this Parker case comes up, brought by a guy named Bob Levy, who was with the Cato Institute. Interestingly enough, the NRA was vehemently opposed to this litigation. The NRA vehemently opposed, it's probably too strong, but they were nervous because they were not quite sure that there were 5 votes on the court to support an individual rights reading of the Second Amendment, and had preferred to continue to win victories at the legislative level where they've been awfully effective, particularly when you had about, throughout this 20th century, you had numerous examples of judicial hostility to the individual rights reading of the Second Amendment, warranted or not. And Levy's bet paid off. He had a good lawyer named Alan Gura who argued the case, and what the court held was interesting. The first thing I noticed about it was it reconceptualizes the right, it modernizes it, if you will. So no longer are we talking about militia, communal self-defense, we're talking about individual self-defense in the home. And what the court basically held was that insofar as the District of Columbia made it impossible for you to have an operable firearm available to you in your house for self-defense, that violated the Second Amendment. At the time, the Second Amendment had not been incorporated, as we say, through the 14th Amendment to apply to the state and local government. I can explain incorporation if you want later. But anyway, so another case had to be brought so that it would apply to states and to local governments. That was the McDonald case, which was decided 2 years later. Still saying that it's about self-defense, there's still this qualifying language that I've called the Heller safe harbor that says now, you know, long-standing restrictions on gun ownership are okay. Lower courts don't go nuts and start striking down all sorts of laws. But this core of the right exists. It's protected by the Second Amendment. And to the extent that you make it impossible for people to engage in armed self-defense with privately owned weapons, you go too far.
Patrick, feel free to add anything to what Brannon said about the Heller decision, and then also maybe talk a little bit about what you think of the court's decision to conceptualize it as an individual right versus a more collective right.
Well, I have so many criticisms of Heller. I don't know where to start.
But it's a long opinion, to be honest.
All my criticisms stem from the historical conception of the right and the Whiggish, or you could say pageant of freedom view of the right to arms, and that there was this one general understanding from everybody at every period from 1689 all the way through the 14th Amendment in 1868. That's completely untrue. It's completely unfounded. I don't know any historian that thinks that's truly credible. Even gun rights advocates that I know of have gone to town criticizing Heller for some of its uses of history because it doesn't go far enough in giving them their gun rights. So no one is really 100% happy with Heller in that regard, and I don't think you'll ever make anyone happy. In fact, I know some opinions right now are arguing that certain things that they argued in Heller are not true, and now this is true. As a core holding, I think Heller is correct, and later on in my writings, if I'm not doing a history and law analysis, which original intent, original meaning, whatever you want to call it, I think Heller's correct, and I think you could say that the Castle Doctrine since the 14th century in Germanic law extended over to England, and the Castle Doctrine basically says I have a right to defend my home if it becomes assailed, and I do not have to retreat in my home if my home is under attack. If you think, and you apply common sense logic that a handgun is one of the most common weapons owned in the United States, that the core holding in Heller is legitimate on its face, the core holding. Everything around it, I think everybody on all sides just want to throw away and write their own new narrative. I think that answers the question.
Yeah. So Brannon, you mentioned McDonald and a corporation, and that was where the court applied the Second Amendment to the states. Talk a little bit about the holding in that case and why it was a plurality decision, so complicated.
In 1835, the Supreme Court decided that the Bill of Rights applied only to the federal government, and that if you wanted to protect your rights against state government, you had to look to state constitutions. Beginning, though, in the late 19th century, the court began to, so then the 14th Amendment was ratified in 1868, contained the Equal Protection Clause, the Due Process Clause, and something called the Privileges or Immunities Clause. Well, the court immediately sort of strangled the Privileges or Immunities Clause in its cradle, or drained it of meaning, or whatever metaphor you want to use. So the court then began to use the Due Process Clause primarily, and then the Equal Protection Clause, to protect liberties, sometimes liberties and rights that weren't enumerated in the Constitution itself. An additional project of this was to begin saying, well, the use of the word liberty in the Due Process Clause can't deprive you of life, liberty, or property without due process of law. That liberty contained all sorts of additional rights that weren't spelled out. And one of the sources of these rights was the Bill of Rights. And the court began this slow process, beginning in the late 19th century, which accelerated in the mid-20th century, of taking the rights one by one and applying them to the states. And the Second Amendment was one of the few that hadn't yet been incorporated. And the McDonald case did that. Now, the lawyers in McDonald, they threw a huge amount of effort behind trying to get the court to breathe some life back in the Privileges or Immunities Clause. In fact, they devoted so much of their original brief to that argument, which was asking the court to reverse something like over 100 years of jurisprudence, that the NRA got nervous and asked to intervene and file its own brief that said, no, don't pay any attention to that argument. You know, hey, we can just do this the good old-fashioned way that you've been doing for 50 or 60 years. And in fact, when Alan Gura got up to make the argument, and he started in on the Privileges and Immunities Clause, Justice Scalia interrupted him and said, "What are you trying to get on as an academic at some law school?" And that was the reaction. And you know, when you stand up to make an argument in the Supreme Court, and the transcript has laughter bracketed in there, you know that your argument has gone off track somewhere. And
I think the right, what he said, darling of the professoriate.
Yeah, that's right. He said, yeah. And Alan's a brilliant lawyer, and I know that he really thought he could sell this argument, and the court was just having none of it. So they quickly retreated and started having the due process argument. Only Justice Thomas said, yeah, I think if you're going to do incorporation, the Privileges or Immunities Clause is the way to go. So that's where you get the 5 votes to apply it.
Mm-hmm. So Patrick, I'm interested to hear your thoughts on, from Heller, both the majority and the dissent used history in supporting their arguments, a sort of originalism approach. Then there was also the approach in McDonald about Alito, how he found that this was a fundamental right. What do you think about the court's methodology? And do you think that given how controversial the history is there any other methodologies that the courts can use to look at the Second Amendment and how it should be interpreted?
Well, I wrote a whole book on this. I think the problem with both sides of the history is, no matter if you're on the dissent or the majority opinion, I think there's just sides, they pick what history they want and they go with it and they take it to the next extreme. And they kind of ignore the other side's arguments. History is not so clean. History is complex. And when we use history to make arguments about the law, we need to do so in a way that's honest and say why we chose X history over Y history versus just saying X is right, you are wrong, and justifying it. And maybe also admit in that opinion that we are not answering a historical question, we are answering a legal question. The fallout from Heller, from a historical standpoint, that has been troubling to me is that people automatically that are very fervent gun rights activists, Heller answered this, you're wrong. Heller said that, that's history. No, Heller's not a historian. No, Heller doesn't change all the documents and everything. Now, it does codify that law, but it doesn't change the way we do it. I would also care to say that moving forward, as I argue in one of my books, is we need to be very careful using history. If we don't have consensus history or something that we can all agree on, the five majority, or to say that, yeah, historians in general agree upon this. This is an accepted historical understanding, that we should not use that as a rationale to move forward. Because what the law is basically taking a certain amount of key facts and then rationalizing upon those facts to come to a legal conclusion. That's what the law is. And the more facts you have and the more closer those facts are and interconnected, the more legitimate that opinion is reasoned and will be supported over time. Now, the further those facts are, which I would argue is Heller, the more illegitimate it will come over time. I would say it's illegitimate in that regard, but as long as we have this fervent gun rights, gun control divide that we're not having a conversation, that's just going to continue. People are going to accept what history they want and move on, and we can't even have the discussion, which is why I wrote the book, to hopefully have a discussion, and I'll say, that's all I have to say about that, if that's all right. I could go on forever.
Sure. Brannon, feel free to respond. And then, off stage, we were also talking about this interesting, perhaps, analogy between the Second Amendment and the First Amendment. Is there anything for how the court has approached First Amendment interpretation that might infer how it should approach Second Amendment interpretation? And on our interactive constitution, we have explainers by Nelson Lund and Adam Winkler. And Nelson Lund's opinion is that courts should be thinking about the Second Amendment like the First Amendment, that it guarantees important rights but not absolute rights, so they must draw lines, whereas Adam Winkler says, no, we shouldn't be talking about the First Amendment with the Second Amendment. It's totally different. So I'm interested to hear your thoughts on that.
Well, I guess two things. Number one, just to round out the comment on history, I think one of the difficulties is that historians usually don't approach historical subjects in order to answer or be informed about the correct outcome of some contemporary controversy. In other words, if you want to find out why the framers were so hung up about standing armies, as a historian, you would just do it, and you would say, well, they were, it was this and that. You're not usually trying to answer or have it shed light on some contemporary controversy, and in fact, many historians will caution, like, look, you can't, it's hard to draw a lot of present lessons from the past, and I think one of the problems with law and history is that we're asking history to provide answers for questions that the participants in the past may not have even understood. They wouldn't even understand what the debate is about. So I think that's probably where you get some of this disconnect and some of the difficulty of having people agree about what the right lessons to draw from history have been. As far as the First Amendment, I mean, I think that the court has traditionally borrowed doctrine. It's one thing to say that the Constitution means X, but saying that the First Amendment protects free speech or that the Second Amendment protects an individual right to arms doesn't help you decide cases. So what the court does is they have to develop these, the academics, I'm going to put on my academic hat now, they call them decision rules, right? These are like the tools that allow the court to implement the constitutional command and provide a result to a case. And I think the court, borrows all the time from different doctrinal areas. And so I don't think there's any reason why you can't analogize to the First Amendment and borrow some of the tools. I mean, the court's already doing so. Lower courts are, the one thing the Heller court didn't do was provide precise instructions about what level of scrutiny, as we call it, to apply to gun laws. And the lower courts sort of thrashed around for a bit and ended up saying, well, intermediate scrutiny. So we're going to require the government to show some evidence that whatever goal it's pursuing is important, and some evidence that the regulation that they propose is going to advance this goal, which is different from the lowest level of scrutiny, which puts the burden on the challenger to prove either the government is pursuing some illegitimate goal or that it's being irrational in the pursuit of whatever legitimate goal. So I think doctrinal borrowing happens all the time, and I think the First Amendment is as good as any for furnishing some of those tools to provide answers to concrete cases.
If I may, I would tend to agree with Winkler, but I put a caveat. So I agree with Brannon that there's going to be certain tests and tools, and that's going to happen. So that they're similar in that regard. But what's happened is there's a movement to try to make the First Amendment tests applicable to the Second Amendment. So basically this idea of freedom of assembly and freedom of speech and freedom of access to information and freedom to publish as being one and the same as carrying a gun. So basically they say, well, if I can carry a book from point A to point B, I should be able to carry a gun. I mean, what's the difference? We're both about freedom. Well, there is a difference. There's a different historical pedigree. Yeah, they're right next to each other, but other than that, they really have very dissimilar histories and very dissimilar impacts in terms of liberty. When we speak of liberty, liberty isn't freedom to do what you want. Liberty also means safety of the community and the communal good and public safety. So in the 18th century, there was this op-ed or editorial which talked about the First and the Second Amendment, and he was using it to basically talk about freedom of press and freedom of assembly, and said, just like there's a line somewhere that prevents the militia from vexing its neighbors, so too there needs to be a line for the First Amendment. You just can't use an amendment for these wanton destruction or injury of people. So there's that aspect. And in the 19th century, these First Amendment arguments start coming in, and especially the late 19th century, as people start trying to argue for a right to carry outside the home. And the courts start answering and saying, well, the freedom of assembly is not the same as the right to arms. The right to arms is very different, and the consequences to liberty from everybody carrying guns as they please could be dangerous. Today, I think we view it differently. Obviously, we've gone to a new society where people view arms as an extension of free speech. You have people carrying arms at free speech rallies saying, I need to carry it in case my right to free speech comes under attack. These are very new ideas. There's no historical precedent for them that I'm aware of. But that's where I would say that, again, so my point of view, if there's someone to take from the First Amendment, would basically mean that there are legal tools that we have to develop tests. And there's a point where history doesn't matter. You have to make a decision that historians don't answer the question. That's the role of judges, and that's their task. It's a difficult task.
Brannon, you can feel free to respond to that too. And then I also want to ask about some of the more pending controversies that have been going through the courts in the wake of Heller, since Justice Scalia did, as you mentioned, Patrick, that the core right was that you have an individual right to possess a handgun for self-defense, but he specifically wrote that this does not mean you have the right to keep and carry a weapon whatsoever in any manner whatsoever for whatever purpose. So now we have all these controversies about, okay, assault weapons, ammunition, that sort of thing, and what kind of scrutiny should be applied to those as well. So I think maybe the first one we can talk about is the assault rifle regulations.
Yeah, so just to add one point about the first, Second Amendment analogy, one thing I think you will see, I mean, I think Patrick is right, at some point the history won't matter because Heller's a matter of fact. So now you'll see, sort of starting from Heller, you'll see this, I mean, to the extent that the court returns the issue, they're not going to go back to first principles most likely. They're not going to rehash the historical debate. They'll start with Heller, and then, it'll develop sort of according to a common law method, taking the principle, deciding whether to extend it or not, or whether it applies to the next case and the next case. And soon you'll get a body of law that's grown up separate and apart from the historical debate that informed the first two decisions. And that's what you've seen sort of with the First Amendment. I mean, nobody has a debate very much anymore about what was the intent of the framers of with regard to the free speech clause or the establishment clause. It just becomes about the case law and the lines of doctrine themselves. As far as the assault weapons bans, I mean, Justice Scalia did sort of create a lot of not uncertainty, but he left a lot of leeway for regulation by that sort of Heller safe harbor. And the question really becomes, he mentions there's no right to carry dangerous and unusual weapons. And I think some of the debate is over whether, assault weapons, assuming you can define it, that's another debate, whether those are truly dangerous or unusual considering how many tens of thousands of them there are in the country and they're available readily for sale. Because he did talk about, weapons in common use. As it happens, the lower courts that have addressed the issue have upheld state and local bans on assault weapons, and I think it's largely because by banning a class of weapons, you're really not necessarily striking at the core, you're just removing one tool. I mean, somebody who wants to engage in self-defense, they can always go get a handgun. And I think that's one of the things that's informed court's decision in that regard.
Patrick, if you want to talk about the assault weapons ban. In November, the Supreme Court recently declined to hear the Colby case, which was a case upholding Maryland's assault weapons ban. And is there anything that indicates why the court may have declined to grant cert, that they didn't want to weigh in on this issue?
I just think because there's not a split right now. If there is a split, they'll hear it, and if they do hear it, it's a very complex issue because if you do history arguments and they have this thing called the civilized warfare test that was created in I think 1937 in Tennessee, and basically it says if a weapon's in common use, especially its common use among people used it as a weapon of war, among soldiers or the militia, then it is a weapon protected by the right to arms. And so under that test, you would say assault weapons are part of common use because there's so many of them in circulation right now, and they've gone on a fire sale because once the assault weapons ban ended, and people on the gun rights side are so fearful that they'll be banned that they just keep buying them in droves. So there's an argument to be said under that test. Assault weapons are somehow protected. At the same time, however, in the late 19th century, they start talking about banning certain things like Bowie knives and dirks and daggers, and these things were all, some of them said they was too broad, some said they were constitutional, saying that, well, these weapons are so dangerous to the public safety that we don't need them. At the same time, I think you can make a stronger argument if the civilized warfare test applies that, well, this assault weapon is more similar for me to produce as a militia. And if I'm going to be a militia, the armed citizenry conception of the right, which is I need to have a gun in case we're invaded by communists, this is the best weapon for me. And this is the problem with history in this area, is that there is so many rabbit holes we can go down that the court can go and make this decision that it will be difficult. And I think ultimately, if they do hear it, they're going to go all down these rabbit holes and see what they did in Heller, and they're going to go to a test. Because they're going to say, we don't want to even go down that road because we did that road before and we were criticized so heavily that it's not useful for us.
Okay, so we have a couple audience questions, and the first one is a similar question. Asks, didn't Justice Scalia support reasonable regulations? And another area now, besides assault weapons laws, are concealed carry laws. And there's a case pending in, I think, upstate New York now about New York's regulation of concealed carry. Do you think, Brannon, that's a closer question than these assault weapons laws?
No, actually, I think, I mean, my own view is that concealed carry is an easier call because up until very recently, well, back up. In the 19th century, I'm pretty persuaded that that concealed carry was tightly regulated, prohibited in many places, and to the extent that a license to carry was available, it was usually left to the discretion of some law enforcement official. Now, this changed about 30 years ago. There began to be a movement from so-called may-issue regimes, where the officials had discretion, to must-issue regimes. In other words, if you could satisfy certain requirements, have a clean record, go through training, et cetera, they had to issue you a license. And in part, this was a reaction to some stories about places like New York. New York City had may-issue regimes, and it turns out that politicians, well-connected people, people like Donald Trump, would get concealed carry permits, and ordinary people who lived in high crime areas and maybe wanted a gun for self-protection could not. And additionally, I think it was also a victory for the sort of pro-gun rights movement really managed to make inroads in legislatures. So really, I think that really that battle, except in places like California and New York, that battle has largely been won in most states. And even in some states where you might not think it would have been successful, I think that moving to that must-carry regime has. But I'm not sure that the Second Amendment requires it. And I'm pretty sure that the framers wouldn't have either, largely because of the difference. The understanding was that in the 19th century, if you were going to go strapped, you ought to be willing to advertise that fact, that concealed weapons were for, riverboat gamblers and card sharps, carpetbaggers, and other, disreputable sorts.
Mm-hmm.
I think we mostly agree on the history. I would just add that, this idea, there was basically a surety of the peace approach in the North, especially up here, for carrying guns. So basically, there was a law that said that you cannot carry a firearm, in public places unless you had a reasonable fear of assault or injury. That reasonable fear had to be imminent. It had to be legitimate. You just couldn't say, well, potentially this person could attack me today. I don't know who he is, but I think he may be down that alley. That wasn't justifiable to the courts of law. And this kind of worked well. And then starting in the late 19th century, they come up with this idea of licensing it. And it's a may-issue license. Now, some local officials just went to town and gave everybody a license, crooks included. They didn't care. They took the revenue, pocketed it, and said, here's your license, go have at it. And throughout the 20th century, actually, gun rights advocates supported May issue laws. And the reason that they supported these laws was because they feared that if they let everybody go armed and these people weren't properly trained or didn't have a proper reason, that more accidents would happen with firearms, and therefore more people would be calling for more gun controls, and then it would lead to more gun control and ultimately confiscation of firearms. They were looking out for their own political self-interest in supporting laws. They didn't really wholeheartedly support them. They would prefer that more people went armed. They always cautioned they be trained. In 1968, I found this in the University of Michigan Archives 2 weeks ago. And Harold Glasson, president of the NRA in 1968, is before Duke Law Forum. And he says at Duke Law School, he asks the question, does the Second Amendment protect the right to carry weapons openly or concealed? He answers his own question with obviously not. And that's the president of the NRA. Now, things change, like Brannon pointed out, in this move to shall issue. And this is the new standard. I want to say 47 of 50 states have it. It's something, it's a lot. And they keep loosening it. Now it's constitutional carry is the new movement. Is why are we even having a license? Is everybody carry a gun as you please? So under that rationale, if we're talking about a living constitutional argument, there is an argument to be made that there is a right to concealed carry, and things have flipped. Now, rather than open carry being, like it started in the South, this idea of being accepted in some areas, open carry is seen a fool's errand because you're advertising to criminals that you're armed, and concealed carry is seen as the better way to go. And the reason I say that there's an argument for, I don't think it will win, but I think there's a legitimate argument to be made because if you are for LGBT rights like I am, and if you look at the jurisprudence 2.5 decades ago, they had nothing. And now they have something. And they have the right to get married. And that is not through any history. That is through living constitutionalism, and that is through applying fair liberty principles throughout and understanding life, liberty, and property and those larger principles. If you apply that and say that there's this living constitutional conception of armed self-defense and having the ability to carry a concealed weapon, then there's maybe an argument.
Well, and there's language in Heller where when Justice Scalia characterizes a right, he says that you have the right to private ownership of a firearm for use in a confrontation. And there was a case from the Seventh Circuit called Moore v. Madigan. And Illinois was the only state in the Union that banned public carrying of weapons totally. And in a Seventh Circuit opinion written by the author of the opinion was Richard Posner, who is a well-known federal judge and one of those federal judges that everybody thinks was probably, it's a shame they never made it to the Supreme Court kind of thing. Well, Posner, who was a bitter critic of Heller and McDonald both, writes this opinion where he says, the logic of Heller can't be restricted to the home. And he goes through this thing saying, there is a right to public carry of some sort. And so Illinois' total ban on public carry can't stand. Now, was this on the part of Posner a good faith application of binding precedent? I have my doubts. I think Posner here was channeling H.L. Mencken, who once said that the spirit of democracy is that people get what they want and they deserve to get it good and hard. I think Posner was trying to show the court that they had, in Heller, created a broader right than maybe the court itself was willing to acknowledge.
This question asks a little bit more about the history. You mentioned that what constitutes well-regulated was what the Founding Fathers saw as a distinction between a militia versus an armed mob. How, if at all, did vigilantes of the 19th century Old West affect this conception? And I would add maybe even earlier incidents like Shays' Rebellion. Was there any sort of relevance to that?
I do not know of anything. The only thing I could say is that as the United States expanded westward, and we got moved west, and then there was more lawless frontier or susceptibility to be exposed to being murdered, robbed, or what have you. People had common sense, and they understood that you needed to go armed in this lawless area. And in San Francisco, there's even an ordinance where they talk about this, and an op-ed that's criticizing, a 19th century op-ed that's criticizing San Francisco's ordinance that prohibits people carrying firearms within the municipality. And the guy criticizes goes, well, technically the town's only yay big, it's only a couple blocks, but this ordinance extends to the whole municipality, which goes like 2 miles that way. Now I can be robbed right around that rock. So this ordinance doesn't make much sense. And he says, now it makes sense like on these streets and thoroughfares where we have, lawmen not to be allowed, but that is going too far. So I think in a sense, perhaps, I don't think it's ever guided the Second Amendment, other than in the 20th century we start talking about, the gun rights movement starts talking about the use of vigilantism and how it's maybe a good idea. Like, there was a time where people just took care of situations themselves. Oh, what a wonderful time that was. Maybe we should return to it and crime would disappear. Americans didn't agree with that, but that's when this idea starts seeping in. Another example I would say was 19th century, clearly this person read my book, which is good. Josiah A.P. Campbell, he was on the Mississippi Supreme Court, and although he upheld this concealed carry restriction in Mississippi, he later comes out and says, I don't think this is a good idea. I don't see this law stopping anybody, especially in places where crime is. Maybe ever we just give everybody a gun and let them have at it, especially women. He thought women should especially be armed because that would definitely stop a lot of crime. No one agreed with him. There was people that supported him. I wouldn't say no one agreed. People supported him, but the overwhelming amount of Americans of that time said, this is a really bad idea. Like, we have rule of law for a reason. We have courts of law. So I hope that answers the question.
It's funny, you read different things about the West and what the West's, and I mean the frontier West, the West approach to regulation was in the 19th century. I mean, on the one hand, I think popular conception, mine included, was sort of, shoot out at the OK Corral and everything. But apparently, in some municipalities, apparently the reality was quite different, that if you came to town, you were expected to go and, I've read some accounts, you were expected to go to the sheriff's office and drop off your gun, before you went drinking and carousing in order to cut down on that kind of violence. But as far as vigilantes go, I think, I'm sure that probably some of it was just a function of spontaneous order and just the lack of any other kind of law enforcement that could be depended upon.
Okay, this question asks, it mentions the sort of war on drugs controversy that's been going on, the sort of crackdown on drug and the fact that it hasn't necessarily been working, and we have this opioid crisis, and if you want to compare that to statistics about murder rates and things like that in the cities, and whether or not if one thinks that the drug laws currently are failing, does that indicate something about what if you think that there's a gun murder epidemic, that gun laws necessarily aren't working either. And in Heller, Justice Scalia, acknowledged that yes, maybe there are some problems in certain cities with murder rates, but this is a constitutional right, and it takes policy choices off the table. So, Patrick, do you kind of agree with that? Should courts take into consideration, for instance, a city like Chicago, where they have a lot of gun violence? Is that something that's relevant to courts in considering the scope of certain rights, maybe different regulations? And how relevant is it, for instance, mass shootings that have happened, for instance, Las Vegas, and the fact that the NRA has even come out in support of, let's say, bump stocks? What do you make of that kind of debate?
God, I mean, this goes to, first I thought you were going with the drug area, then you went, so I was ready for that answer. Firearm localism made sense for so long. Even the NRA supported firearm localism, I think, until the Morton Grove case came down and they appealed at the Supreme Court. The first to argue against firearm localism, this idea that states and cities and municipalities need to have stricter gun laws than, say, the rural areas, was the National Shooting Sports Foundation, and they came up with these ideas. They call them model firearms legislation. Basically, they borrowed this idea of if you adopt model firearm laws in different states, then it brings uniformity and it prevents, it provides uniformity of laws to help shore up the areas that have less gun laws, but also it protects hunters, gun owners, and sportsmen in that, and it will ensure that they don't get snared by some local rule that they were unaware of when they go traveling with their gun. What it's ultimately become is this localism is they realized that the NRA, they first said localism is a great idea because they said, well, you know, every place is different, and maybe New York should have that law, but that shouldn't be here in Wyoming. They later changed their mind because if you can preempt and get rid of localism and say the state controls all firearm laws, then you just took away a law or issue that the NRA had to fight, so they got rid of it altogether. And now that the Second Amendment's incorporated and you know, there has to be a national standard and it has to apply uniformly. You can't say, the court of law can't say that, this is maybe where First Amendment crossover is, that you can't say that, you know, in one county you have this First Amendment freedom to put this sign in your yard and then say, well, in this other place that could cause dangerous, it could cause a riot maybe, it's in the city. So, you know, that's a very offensive sign. You can't do that. In one area has to go in the other. So I almost want to say that we've kind of moved against ways against localism, but I also think that the court is going to be very lenient in allowing for gun control experimentation. The problem gun control has is that you can't say a life has been saved by a gun control provision because the person didn't die. You don't know that the gun control provision worked. We don't know how many people are saved every day by them. And that's the same with all preventive laws, whether they're medical laws, you know, pills laws, or traffic laws. You can't say, this law saved 2,000 people today. But we have them because they're common sense, and that we want to save somebody's life. And the argument used to long be is, in NRA support, even if it saves a couple of lives, it's a good law. We just can't verify what lives are saved. I hope that answers the question. Sometimes I go off on tangents.
Let's see. Go back to the drug laws, gun laws thing, and then talking about, let me start back with the bump stocks. I think it was an easy issue for the NRA. They needed to, I think, from what my friends who have a lot of guns, they say they don't work very well, and it takes a lot of training to get good with them. And so, you know, and if you were the NRA and you needed to be seen to give on something, that was probably an easy give because I don't think they're terribly common. I mean, not a lot of people use them. And so I would say that's probably why, as a strategic matter, that's why they gave on that. As far as, you know, drug laws, gun laws, I don't know. I mean, what I thought you were going to say is, what I thought the questioner was going to go is talking about the intersection between legalization of marijuana and gun laws, and I'll come back to that in a second. But I don't think, I mean, people speed, but we have speed limits. I mean, simply because people break laws for various reasons doesn't mean that we shouldn't have them. And I think the question is trying to ascertain the right mix of regulation that's effective, that's you know, that passes some sort of cost-benefit test. I mean, I would disagree. You know, that you do hear, if it only saves 2 lives, it's worth it. Well, if it saves 2 lives at the cost of $3 trillion, then, you know, I don't know.
Public policy, that's not a good. That's
yeah,
not a good
I mean,
election.
that's, you know, because of the opportunity cost that $3 trillion would go to. I think that the more interesting the debate, and the one that I hope emerges now that the Supreme Court has protected a core right and said, yes, there is a constitutional dimension to the gun control debate. So if you are a law-abiding gun owner, confiscation, total bans are now off the table. I was hoping, and this maybe is beginning to happen, but I'm hoping that that's a place that you can begin to build on to say, okay, you can't ski the slippery slope all the way down. The court has closed that option off. Now let's start talking about, let's have a debate about what is reasonable regulation. Let's have a debate over which of possible choices to reduce gun violence are actually going to be effective without impugning the rights of law-abiding gun owners. How do we get the guns out of the hands of bad guys and try to reduce some of these just simply horrific levels of violence in cities like Chicago or DC, which, by the way, have very strict gun control regimes in place. So something's not working there.
Patrick, so last word to you if you wanted to respond to what Brannon said, and then also maybe what do you think the future for Second Amendment jurisprudence is? I know you mentioned if there's a circuit split, the court might jump in, but what do you think the chances of that are versus kind of letting the lower federal courts parse out what might be a reasonable regulation or not?
To add on what Brannon said, you know, I wholeheartedly agree with his thing that we need to start talking about what's a reasonable regulation. My fear is that we really can't have that discussion as long as we have lobby interests or people dedicated to rebutting every argument that could be a reasonable regulation and trying to find some reason why it shouldn't be passed. If it's good regulation, then you argue, oh, well, it's going to cost us too much money, or that's going to be too difficult to enforce. Just to enforce this law, there's all these talking points that existed for time. This has been a century-long debate about what is reasonable, and it's not an honest discussion in many ways. In some ways, it's very enlightening, and I hope you read the book and see what that discussion has been going on for a long time. And the discussion we're having today is in many ways parallels what they were having in 1918, 1920, 1960s especially, if you look at where we're at today and the parallel with the political conversations we're having. In terms of the future of the Second Amendment, I'm kind of hoping common sense prevails, that we look at it and we come up with some reasonable tests that say, could this potentially save lives? Could it not potentially save lives? Is it enacted with a nefarious purpose? Does it deny law-abiding gun owners the ability to have guns? Is that the sole purpose of the law, to basically just prevent these people from wanting to purchase guns? Not what a lobby says that's what the purpose is, that this is in fact the purpose. And in those instances, you know, we should probably strike those laws down. I don't know if it would go to that, but that's my hope. If we're gonna move forward as a democratic republic, and at least one that can have open and honest conversations. Although I think all you watch the news, you know, it's basically just extremes these days. They don't put reasonable people on TV because that doesn't get ratings. Nobody wants to hear someone say, well, it could or it couldn't. They just, you know, you want to hear your side and that's it. And maybe the court will step in and really answer this debate for us.
Great. Patrick, Brannon, thank you so much for joining us. And Patrick is available after the program to autograph books if you want to pick up your copy. So thank you so much for coming. Thank you. Thank you. Thank you.
Thank you so much.
Thank you.